It's been my observation over the last 20 years or so that people, when they're bargaining with positions, they tend not to plan how to do that ahead of time. And they get into this, what I call reactive bargaining, where you make a proposal and I don't like it and I want to try to get you to come lower, and so I lowball you, but that only produces a high ball on your side, and you get so where you stall out early without ever finding out what your real numbers are. And we try to help people get beyond that by developing a plan of movement. Where am I going to start? Where am I going to walk away? And how do I move in between? And not get into the trap of reacting to the other side. My name is Andy Little. I'm from Chapel Hill, North Carolina. And I'm a lawyer down there. I practiced law for about 20 years, trying lawsuits in all levels of court. And I became a certified mediator after that. And I've been mediating settlements for 21 years now. Most of the literature of negotiation and mediation is built upon what's sometimes called the Harvard model, an interest-based negotiation model. And that model is distinguished from what they call positional bargaining, which is, I want it, you can't have it. That's the way most of those arguments start. The theory in the Harvard model is that if you can get people away from positional bargaining and help them understand what problem they're trying to solve in the first place, what interests they have, what are their goals, you can help them come up with creative solutions, win-win solutions, rather than just kind of horse trading toward a result that often doesn't happen because it's a very hard way to bargain. Most of civil litigation is based upon disputes that are about money, and they end by somebody paying somebody else a certain amount of money. It's all about positional bargaining. So I'm trying to help them understand the dynamics of positional bargaining and what they can do from the mediator's side to help lawyers get over the hurdles, and what lawyers can do to help themselves get over those hurdles as they're preparing for mediations and negotiations. Lawyers still haven't put negotiations and preparing for negotiation on the same level as trial preparation, and so we went through a whole litany of things that they can do to set aside time for planning, both with themselves and with their clients, and to do that on a more systematic basis and a planned basis well in advance of mediations and settlement conversations. So I won't go through the laundry list, but it was about treating negotiations more seriously and setting aside time to plan, to try to help themselves and particularly help their clients understand better the value of their case. So we talked about more systematic study and understanding of the pieces of the case that go into determining value, like the liability issues, chances of liability, damage issues, and how likely it is they'll get those damages. Just understanding your case better. And the principal tool we talk about there is what's called litigation risk analysis, which we went into in some detail. So giving them some tools to help them with that process. Most of us as lawyers didn't get training in negotiation when we were in law school anyway. And so the first thing is to set aside kind of a deliberate schedule of learning how to negotiate better. There's some great books out there, both from the Harvard model, and there are beginning to be some books on positional bargaining. I think mine was the first. It's called Making Money Talk, and it's all about positional bargaining in the context of civil litigation. So setting aside reading the schedule, attending trainings. We highly recommend that people take mediation training to learn how to be better negotiators, because you learn a lot of the principles in mediation. That's where I first learned about negotiations at all, was when I took a mediation training at a local community dispute settlement center in my hometown.